And without further ado, I want to go ahead and bring on Raees, the beard lawyer. Raees, thank you for coming on. Thank you for taking the time. I look forward to having this discussion with you. Before we get started, just take a moment and tell everybody a little bit about yourself, who you are, what you're about, and we'll take it from there.
Yeah, Raees Mohamed. I'm an attorney. I do a lot of internet defamation work. So I deal with the First Amendment quite a bit. Usually that means, you know, false reviews, false advertising campaigns, and sometimes it's a smear campaign like the one we're about to talk about. And, you know, I represent creators of all sorts. Some of them are celebrity-esque. Some of them are just starting out. Some of them are names you've seen, people on cover of magazines. And we do a lot of litigation. My practice is nationwide. I'm a co-founder of my firm in Scottsdale, Arizona called RM Warner. And yeah, we deal with the underbelly of the internet is what I like to say. And we have the less sexy, you know, commercial practice where we help startups and entrepreneurs like yourself with the life cycle of their business. But the internet side of things, defamation, free speech, that's definitely where the real stuff is.
Have you ever represented an obscure YouTuber like myself? I'm just joking. You know,
pretty much every other day. Yeah.
Yeah. So this case is pretty wild. I don't know where you want to start, but I'll let you start wherever you'd like to, because I would like to go through the merits of it. I'm going to go ahead and pull that up in just a second, and we can jump to any page that you would like. But, you know, talk a little bit about, and I just did a kind of a reaction video, not even like, I guess almost a reaction to reaction video. And I also laid out some of the additional things that Candace said in response to this. So first of all, I would like to know, like, if you are Candace's lawyer and she's continuing to comment on this case specifically, like, what would your advice to Candace Owens be?
Yeah. That is a great question to kick things off, because every lawyer's nightmare, Gary, is a client who does not shut up in middle of litigation. I don't know how to say it, you know, more eloquently than that. No, look, I have a lot of cases that are popular against social media people, influencers, people in the public eye, whether it's plaintiff or defense. As a lawyer, you do not want your client talking freely about your case for many reasons, Gary. One of the reasons is because it can unravel your claims or defenses. And you don't have the benefit of your lawyer sitting next to you, usually. You don't have the benefit of having a lawyer script things for you, usually. And so even something as small as a one-liner commentary, I almost always advise clients against that. So you typically are not doing yourself a favor by talking about litigation. Now, there's exceptions, Gary. Sometimes there's a media strategy here, and maybe that's what's going on, right? And we could talk about the brass tacks of what kind of campaign you should be engaging in, if any, when you are a defendant in a defamation case, rather. But generally, you don't talk about your case.
Well, one thing that's been parroted a lot, and it's not just on this case, it's been on other cases, and specifically, I hear it all the time, literally every day, in the comment sections of our videos regarding Candace Owens, whether it's the Macron case, whether it's, you know, the Harpool case, or potentially even a Erica Kirk case. We keep hearing, like, thank God you guys have no idea that this lawsuit just opens the door for Candace Owens, but you can stick anybody in there that's being sued, for discovery. Like, this is what she needed. This is what she wanted. So now she has discovery, or this person has discovery. I think there seems to be a lot of internet and ex-lawyers out there, and having discussions I've had with other lawyers on the show, and I've had these discussions off camera with a lot of lawyers. Discovery doesn't seem to be the panacea to, I don't know, all powerful, getting to dig into somebody's past and using that information to defame them further, that a lot of people think it is. Can you kind of, whether you use this case or whatever example you want, like, talk about the scope of discovery, how it can be used? You know, can they go in and, like, dig through pretty much any sock drawer that you have and come up with information that they're going to use against you later on. Is that how it works?
Yeah, I'm laughing because anyone who thinks that getting sued is good because you're going to get an opportunity for discovery is an absolute idiot. Absolutely idiot. Like nonsense. I mean, no lawyer will disagree with me on this, by the way. Okay, no practicing lawyer. You're looking at somebody who's in courts across the country on internet defamation issues, somebody who has to go through cell phone forensics, somebody who has to go through email exchanges, redactions, protective orders. People, there's externalities, there's splashes of people that you don't want to get into litigation. They get pulled in as witnesses, right? It is nasty. So let me just frame this as saying it is not a good strategy to say, I can't wait to become a defendant because of discovery. Period. Dumbest thing I've ever heard. Okay. Now, that doesn't mean that discovery can't be helpful. Okay. It doesn't mean that you won't enjoy discovery. Now, I've never had a client, after paying my bills and going through deposition prep and going through depositions and sweating through their suit and being on camera, say, Raees, I love that deposition. Can we do it again tomorrow? Like, it's absolute nonsense. So no, it is not a good thing to go through discovery. As a matter of fact, most defendants in internet defamation cases know that you try to resolve cases before discovery, particularly, and I say internet defamation cases, Gary, because they are forensically heavy. Okay. Imagine someone, I'll frame this for you. Imagine someone, let's say hypothetically, you are a YouTuber, blogger, you have an Instagram channel, you have millions of followers, and you are getting DMs on Instagram over the course of a year. You said something defamatory, you get sued. Your defense is going to be, well, I've got the DMs that I use to support the statements that I made, and therefore it's exculpatory. I don't feel like I have fault. I have some reasonable degree of research, and it's in my DMs. Perfect. As plaintiff's counsel, I'm going to get to forensically copy your phone, the whole phone, indiscriminately to a degree. Then the plaintiff and defense lawyers get to fight about the scope of search terms to narrow the scope of relevancy. And then we get to do the deep dive into the documents that are produced. Now, if the sheer fact of handing your phone over to a lab doesn't make you, nauseated, there's something wrong with you. And it's not because the arguments like, why do you feel like you have something to hide? It's the same argument I tell people when the cops knock on your door without a warrant, because we have laws. It has nothing to do with, well, if I didn't do anything wrong, I'm okay. It's intrusive.
Right.
Okay. So forensic discovery in your devices, in your Instagram DMs, in your text messages, your emails. Gary, guys say crazy things in text messages with other guys. Women say crazy things in text exchanges when it's just the girls. That could potentially come out in discovery. Okay. So when I say internet and forensic discovery is nasty, it is nasty. So, and we'll talk about Candace in a second, the scope of discovery. It doesn't mean the whole world becomes available to you in litigation, but it's not something you want. Okay.
Yeah. The other thing I kind of want to get out of the way before we get into kind of the meat and potatoes of this particular case is the balance of the First Amendment, what it actually protects versus, like what you can't say. Because look, I think all of us we hold the First Amendment sacred. And the First Amendment generally applies specifically to the government. There's a reason why we have these defamation laws on the books, where you can't just go around and just abuse the freedom of speech to abuse others. Kind of lay out the legal perspective of that and how you see that and how other people should kind of weigh the pros and cons or the limitations of protections of the First Amendment when you are just going out and defaming people.
Yeah, that's a great question. I'm going to talk a little bit of history for a second, because I think this is what makes America special. The First Amendment is uniquely an American thing, right? When the founders of this country left the crown of England, one of the things that they decided very early on, and very intelligently so, was that we do not want the crown. And at the time, remember, the government's not formed yet. Right? This is in the mid 1700s. They're debating this idea of, well, how free do we want people to be? On one extreme, the founders talked about, well, the government should have an opportunity to control certain things because we don't want chaos. On another extreme, you had people arguing the government shouldn't get a say into anything. Everything should go. And what comes out of this Jeffersonian, Madisonian debate is supposedly the middle ground, which I believe the Constitution, when inked, is a middle ground, okay? And what they decided was, we don't want the crown from England. We don't want to have to live under that oppressive regime where they can tell us what we can say and think and talk about, including in newspapers. So they came up with this thing called the First Amendment. Now, the First Amendment is first for a reason, Gary. It's the most important, no coincidence, second to second. Two very important amendments. But the First Amendment, which includes free exercise of religion, right? The freedom to practice your religion and freedom from religion, both. Freedom of speech, freedom of the press, all these freedoms that we generally know about and talk about. Freedom of the press and free speech is at the dead center of today's talk. And what people need to understand first is free speech is a right you have against government actors. It is, the Constitution is a set of rights that you have against government entities, state, federal, and its municipalities. It is not, they are not rights that you have against private parties, private citizens. Why does that matter? If you wear a shirt that says, oh, there's plenty of examples. If you wear a swastika into LA Fitness, you cannot say you have a right to express support for the Nazi party in a private gym. They can kick you out.
Sure.
It's a private place of business. Now, if you wear that same Nazi symbol, and I'm choosing Nazi symbols for a reason because there's actually cases on this. If you wear that shirt into a police department, technically they cannot tell you to take the shirt off because that would be censorship of a viewpoint. So that distinction is important, okay? Freedom of speech is also limited in private places of employment. Now, if you work for a federal or state government, that's different. But if you work for Intel, Motorola, Meta, TikTok, those are private companies that allow enforcement of, for example, what you can say during your job hours, all right? Now, in the last 2 or 3 years, we've seen a lot of pushback of people getting fired for their private speech on social media, right? And then the argument is, well, freedom of speech. And I'm like, wrong argument. You don't, freedom of speech is not what protects you from your employer. Discrimination laws might, that's different, okay? But that's the first thing people always get the boundaries incorrect on. Freedom of speech, First Amendment, is a right you have against government actors telling you to censor viewpoints. So, Raees, what can we censor? What are the rights that you have the ability to express under the First Amendment as it relates to free speech? And it's viewpoints. That's the key word, viewpoints. It's the government does not have a right to censor your opinion or facts on a particular perspective because the government doesn't like what you're saying or doing. Doesn't matter if it's a Republican government, a Democratic government, a Green Party, period. Censorship of viewpoints is against the First Amendment, period. That is the heart of the First Amendment. So when the government tells you what to think and what to say, or stops you from saying or thinking something, that's a First Amendment violation. And by the way, these things happen. I mean, states have tried to pass laws that violate the First Amendment. Sometimes the law stays on the books and then it gets into the court system and it gets overturned. You see this, by the way, in pornography, in laws that try to curtail pornographic content or adult content. And the debate's not whether having porn is meritorious or not. The debate is, unfortunately or fortunately, that type of speech is protected under the First Amendment to a degree. Again, and there's some government. So the government does have a right to curtail it to some degree, reasonable time and place restrictions. You may have heard this before. That's what allows a government to say, hey, you can protest on campus, but you got to shut down at 9 p.m. because that's when, you know, officers go home, from campus. Or, hey, you can stand on the street and you can hold flags for your favorite country or soccer team or whatever, but you can't do it in the middle of the intersection. You have to stay on a public sidewalk, right? Those are reasonable time, place restrictions. The government's allowed to do that. It's not a First Amendment violation. And to go even further, if you block traffic with the gigantic sign, even if you're on a sidewalk, it's really a common sense thing, Gary, but people lose sight of the point of the government's role. It's not to tell you what to do or think, it's to provide for safety and regulation. So that was an earful, but that's sort of the core of what the First Amendment is and what the government can and can't do.
Speak just very briefly, at least, let's talk a little bit about specifically to defamation of other people or entities. I guess it really doesn't matter whether it's a private entity or not. Again, people are like, hey, I can accuse, if I'm accusing somebody of murder, or I'm implying, and that's another thing I want to get to you to discuss. If I am directly saying or accusing someone of murder, or whatever it is, something clearly defamatory that is intending to damage their reputation. What are the protections that the First Amendment does or does not bestow upon that person that is launching those accusations?
Yeah. So what I didn't mention in my definition is what the First Amendment does not protect, right? And one thing is what we call fighting words. And that comes out of case law, actually. And it's words that provoke people, words that are designed to really incite violence and harm.
Sure.
Are not designed to be protected. Let's start there. That's an easier category. Right? And this is the proverbial yelling fire in a crowded movie theater, which, by the way, comes out of a case. There's no freedom of speech there. But also, lies are not protected. Purposeful, false statements of fact. And as it turns out, what is a false statement of fact is debated around courts around the country every single day. It's what we do. Okay? So we'll talk about that. It's very relevant to Candace's case. But false statements of fact are not protected, period. So when you make a statement that is a false statement of fact that injures or tends to injure someone's reputation, and you say it with at least a degree of negligence, you were not reasonable as a person in investigating those facts, and you cause reputational harm, that's defamation. And defamation is not protected under the First Amendment. Now, there's different standards and different occasions that apply. I talked about negligence. That's for the average person. If you are suing a news media company like CNN, then the standard for CNN is reckless or actual malice, meaning you have to prove, if you're suing CNN, that they said something with knowledge of falsity or reckless disregard for the truth. That same standard applies if you are a public figure, if you're a celebrity or a well-known person in your niche, and you are suing for defamation. And the logic is easy. The logic is, for media defendants, you know how it is. News flies quickly, right? Yep. You might have a breaking news, you turn your camera on, and you don't have all the facts right, Gary, right? You're on the street, you're filming somebody, a witness says something. We can't hold you to a negligence standard. We hold you to a knowledge of falsity standard, okay? And that's reasonable. That comes out of a case from the 60s called New York Times v. Sullivan out of New York. And there's very clear, well-established law that media defendants, when they're sued, the standard for their speech is knowledge of falsity or reckless disregard for truth. It's up here. It's high burden. Same thing for public figures. And the logic is simple. Public figures, if you are suing because your reputation was harmed, as a public figure, you have to prove knowledge of falsity or reckless disregard for the truth for the statements made about you, because as a public figure, you have a platform for influence. So we won't punish people who are merely negligent talking about the highest office, right? The president, or celebrities, Johnny Depp, right? We don't punish people for talking about celebrities if they're just negligent. We only punish them under defamation laws if what somebody says was a fact that was purposeful. It was knowingly false. So defamation, not protected free speech. And unfortunately, I'll say this, today we live in the era of falsity. You know, as a practitioner in this space, Gary, my biggest, I see it every day, 10 times a day. People saying things they should not say. Everybody is entitled to an opinion, right, on something. But where you cross the line from opinion into fact, that's where liability starts. And I'm going to give you an example. You're allowed to have an opinion that says, hey, I think that there are reptilians in Congress. You can opine that you think the earth is flat. Maybe that's going to upset some people today. What you can't say is, you know what? I saw Gary testifying in Congress on weapons, and then he went to the bathroom and dude turned into a lizard and crawled right into the toilet. Or hey, you know what? I was in NASA's office and they were talking about editing all the pictures of the moon landing. And I was in the room when the astronauts had this discussion and when the scientists were talking about it. And they were literally saying that they want to make people believe that the earth is round when it's really flat. You can't say stuff like that because there's no protection for misleading the public. And what's interesting is there's a gray area, Gary, and I'm giving you some concrete examples, but it's not always concrete.
Sure.
And you know, you remember tabloid magazines at the grocery store back in the day, and now you have websites like Babylon Bee and The Onion, and there's rhetoric.
Right. There's
satire. This is why suing Saturday Night Live will never work very well, because it's comedy. It's not, nobody listens to Saturday Night Live for the facts. Right. They listen for a good chuckle. Okay. And same with music. A practical example is, you know, did you follow the lawsuit of Drake when he sued Universal Music Group over Kendrick Lamar's diss track where he called him a certified pedophile? You know? I
knew about it. I didn't follow it. I heard on social media, everybody else.
So most people are familiar with Kendrick Lamar and his song "They Not Like Us," and you know, Drake. Everybody knows who Drake is. Filed a lawsuit against Universal Music Group, his own record label, by the way, because he felt that they were helping to promote Kendrick Lamar's "They Not Like Us" song, and that there should be defamation liability because Kendrick Lamar called him a certified pedophile, which is repeated in the song. Drake is a certified pedophile, and that he likes them young and like under the age of 16 and da-da-da. That sounds nasty, right, Gary? If you said, Raees, nobody can call me a certified pedophile, right? That's defamation, dude. I would say, well, time out. What's the context? What's the context box in which the statement was made? Because that's part of the analysis. It's not whether you had hurt feelings. That's not why you sue somebody for defamation. You sue someone for defamation if the statement is a false statement of fact and a reasonable listener would believe it to be true. Okay. Well, when people are listening to Kendrick Lamar, are they listening for like Bloomberg News? And for that matter, it was known that Drake dissed Kendrick Lamar on a song. So Kendrick Lamar was writing a response to that. And he called Drake a certified pedophile. And this got litigated and it went to some of the best judges, okay? And it went to some of the best courts who deal with this issue. And the ruling was the case was dismissed because certified pedophile was satirical. It was a song. Nobody believed that Drake was a pedophile because of something Kendrick Lamar said in a rap song, period. Right. Now that's appealed. Drake is upset and it's, you know, that's ongoing, but that's the ruling. And I think it's the right ruling, by the way, because music is one of those ways to speak out, whether it was NWA or Rage Against the Machine or Metallica. People are talking about causes and political issues. That's one of the most protected things you can, one of the most protected categories of speech. It's artistic.
Yeah. And it's not always meant to be literal.
Exactly.
Yeah.
Right. Now, this is one of the reasons why suing comedians for defamation will never work. This is why suing Saturday Night Live and musicians Now we get to bloggers and YouTubers, guys like you, or
Mhm.
people like, oh, I don't know, Candace Owens. What about them? Do they get a right to say whatever they want and be completely free from liability? And as it turns out, the answer is no. And we talked about a couple of categories already of what you're entitled to speak. You're allowed to speak the truth, which is an absolute defense to defamation. You're allowed to speak your opinion, much like you do on your channel, right? You get people on, you've read articles, you've done some diligence, you talk about your opinion on a topic. Opinion speech, when it's about something that's of grave public concern, gets a high level of protection, one of the highest. You'll see it in the statutes across the country, anti-SLAPP statutes and First Amendment statutes. Statements about public concern. What's a public concern? Public health is a concern. Security is a concern. You know, political issues that are wide sweeping are public concerns. Private matters about people's private lives, those are not considered public concerns. And we'll talk about some examples from Candace, from things Candace said. But it makes sense, right, Gary? If there's an issue that's a headline that immigration, policy, speaking about political figures, those things get strong protection because people in America should be entitled to have a discourse like we're having. And you should be entitled to voice an opinion, no matter how egregious it is. This is where it gets interesting. Now, I'm not an academic. I'm a practitioner. I'm the guy that argues in courts. I'm the guy you come to if you're sued for defamation, or if you want to say something. I have clients who come to me who want to engage in a campaign and say, what's the furthest I can say without getting sued? So that's the guy you're talking to. I'm not some, theoretical person.
Right.
The reason I say that is because the line between what's an opinion and getting sued for a false statement of fact is sometimes very blurry. All right. Conspiracies can be opinion. All right. Let's talk about some practical examples. Alex Jones, one of the leading conspiracy theorists, if you want to call him that, content creators, been around for a long time, very successful. Unfortunately, he got sued for defamation when he said that Sandy Hook was a false flag operation. And the jury hung him so hard. $1.5 billion jury verdict, probably one of the largest ever. And he's a media guy. Remember, the New York Times v. Sullivan standard applies. That's knowledge of falsity. So when the Sandy Hook plaintiffs, the family sued, they proved that he knew what he was saying was false and that it was egregious. And the jury did not like him for it. I mean, they punished him. And that is where content creators and bloggers need to really, really, really dial it in and be careful. The moral of the story is not everything you say can be protected. You can't abuse the system. And Alex Jones went a little too far. And I think the jury got it right. Some First Amendment academics will say, well, he should be entitled to say it. That's his opinion. But again, he didn't say it was his opinion. He said it was the truth. He said there was evidence of it. Key word, evidence. And there's other examples where, do you remember the CNN, Zachary Young? Do you remember that case?
Yeah.
The veteran.
Mm-hmm.
For those who are listening, Zachary Young, brilliant lawyers, sued CNN for defamation. Again, a media defendant, very hard case. And he won $4 million in compensatory damages and $1 million in emotional distress against CNN because he proved that when CNN said that he was smuggling Afghan refugees out of the country in a black ops operation, that they knew when they said that it was false at the time they said it. And that is huge. Most people think, oh, you can't sue CNN. They're newsworthy. We just talked about the standard and the fact that, breaking news moves quickly. But Discovery, remember, we talked about Discovery, what comes out in Discovery, the notes came out. The email chains between the reporters and the producers came out. And guess what it showed? It showed that CNN reporters questioned their own veracity of their story that they were about to air. And they aired it anyway. And that's irresponsible media reporting, period. And the jury punished them. And after the $5 million jury verdict, CNN then settled because so the way this, you may know this, Gary, after a jury trial ends, after there's a damages hearing, the jury decides, right, how much to award. Then there's what they call punitive, which is to punish. And most states allow punitive damages in defamation cases. That part of that trial was yet to happen. And CNN learned their lesson. They're like, dude, we got mopped and there's no ability to appeal. So we're going to settle. So we don't know how much CNN paid Zachary Young. But my guess is it was around $5 million because they goofed. And so I bring those two examples, Alex Jones and CNN, because if I'm Candace Owens and I'm her lawyers, I'm studying those cases right now. Okay, I'm talking to the lawyers from those cases to the extent that they can talk to me. I'm pulling all the motions that were filed and I'm studying them. Why am I studying them? Because I want to get in the minds of people who've met the standard of knowledge of falsity. And I want to compare it to my case. Brian Harple and his lawyer should do the same and say, hey, do I have cover? Do I have cover for the statements that I made, me being Candace Owens, on my podcast and on my channel? And this is where we can get into some interesting conversation about what I'm seeing as a defamation attorney in the case. But that's what I would do.
The last question I want to ask you, and I'm going to leave you the option that maybe we'll get into this specifically, but the other defense that I hear a lot from the Candace crowd is, oh, we're just asking questions. You know, when you consistently imply that someone is guilty of something over and over, you know, it's almost like making a statement and throwing a question mark at the end of it. And then you clearly look at, and this is what Dylan Law is clearly doing, because they actually have screenshots of some of her fans' reactions. When you look at, there may be an implication there, a suggestion that this person is guilty, but everybody in the comment section is coming to the desired conclusion of Candace, for instance. And it's like, yep, 100%, you know, Erica Kirk was involved in this. Like, how much cover do these implications, do these innuendos cover the speaker?
That is a great question. And I want to give hats off to Brian Harple's lawyers. He has a great team of lawyers. The reason I say that is I read every line of the 69-page federal complaint. And it is alleged very, very well in detail. Some would call it maybe overdone. I like this complaint, okay? From the standpoint of a technical analysis, they did a great job. They really did. Here's why this matters for your exact question, okay? When you are a content creator and you are asking questions, and there's nothing wrong, Gary, we do this as lawyers. We ask questions to lead people down the logical sequence of events to get them to arrive at a conclusion that we want them to arrive at, right?
Right.
That's good journalism. But when you say, and let's go right to it, when you say, hey, I have access to flight records before I publish this statement, and this guy was definitely at Fort Huachuca, you're not asking anymore, you're telling. And what the complaint does a very good job of saying is the actual malice standard, because the lawyers knew, again, good lawyering, they said, well, we know Candace Owens is going to come back and say, you're suing a media defendant. You need to show knowledge of falsity. And good for them. They stuck it in the complaint. They actually say, you're not leading a conversation. You're telling facts. You're not telling an opinion. And there's at least, I mean, I took notes on this complaint because I'm kind of a defamation nerd, and I went through and I jotted down in a Word document, but there's at least, Gary, there's at least 6 categories of false statements and probably 12 to 15 false statements. And there's a gradient of what's considered worse, right? There always is.
Sure.
But to answer the question more succinctly, I don't agree that Candace was just asking questions. As a lawyer, and I'll put this disclaimer: I haven't watched every minute of Candace's all of her podcasts on this topic, but I have watched a lot, and she has crossed into the objective fact-telling versus question asking, in my opinion, as a lawyer looking at this in a neutral way. And again, I think the lawyers for Brian Harpel did a good job of alleging it and identifying what those statements are.
Well, let's go through that. Like, I'd like to kind of go into a couple things. Number one, what do you think some of the most damning evidence against Candace is? And then I'd like to play a little bit of devil's advocate of, like, if you see a possibility of this lawsuit not being successful, where those weak links are in this, and or maybe how the judge and or jury would perceive this lawsuit and potentially dismiss it, or he would lose the lawsuit through trial. So I got it up right here. You just kind of take us through this. Anywhere you want to start, if you have any notes, or we can scroll through this, however you want to do this.
Yeah. Why don't we go to? Can you make this a little bit larger on the screen, maybe, so we can see more of the document at once?
Oh,
maybe zoom out a little bit and just make the PDF file itself bigger. Yeah.
Yep.
Okay. Zoom in a little bit more.
Okay.
It's a little pixelated. All right, there we go. Because then that way viewers can also see it with us. So a couple of things, right, before we get out right into the nitty gritty. One is understanding who's being sued here. Mm-hmm. And you're on the exact paragraph where it identifies, at least starts to identify who it is. This is important because one of Candace Owens' sources, this guy Mitchell Snow, who's an interesting character. Man, I just have to laugh. I'm sorry. I'm a lawyer, but I get to laugh too, right? I mean, interesting character. And so Candace Owens, her production company, Candace Owens LLC, George Tom Inc. is a defendant, and Mitchell Snow, all of them are defendants. And the gist of it, for people who don't want to read all 69 pages, is that they all four conspired and aided and abetted one another to defame Brian Harpel. And what that means is they acted in concert. So they knew what they were doing, and they had this sort of understanding that they would publish false information about Brian. That's the gist of it. Let's jump right into the brass tacks of some of what I think are the worst. Can you go to paragraph 36?
Sure. There we go.
Okay. In this episode, Owens claimed that on December 8th, 2025, she received a credible tip from a former military member, first referred to by Owens as Harry Myers, later identified as Mitch Snow, claiming that he inadvertently entered a classified meeting at Fort Huachuca on September 9th, 2025, the day before Charlie Kirk's assassination, observed senior government officers in attendance, and that following the assassination, identified Harpel as one of the individuals present for the meeting. Parenthetical, it's unclear how someone can, quote, inadvertently enter a classified meeting at a U.S. Army base where the government was secretly plotting to kill a prominent political activist, but Snow claims to have pulled it off. Upon information and belief, it was during this December 8th conversation that Owens and Snow agreed to enter into a conspiracy to defame Harpel by using Owens' network, including her podcasts, social media accounts, and websites, blah, blah, blah. This paragraph and the next, I would say, 37, 38, and 39. Here's the problem. Let's just say Candace Owens is of average intelligence. You don't have to believe that or not. Let's just run with that, okay? A reasonable reader who's listening on a podcast to someone who says, I received a credible tip from a former military member who entered a top secret meeting. Here he is, And he told me he saw Brian Harpole, and he's here, guys. He's going to talk about it. Right off the bat, problem one is it's a fact. You are conveying facts that this guy was there. Now, here's the easy defense, and I say easy with an asterisk. There's a footnote here.
Let me add that just a little bit too, because she also predicated the first episode about Fort Huachuca as I don't see how, after I tell you this, people, I don't see how there's any other option but for the U.S. military, and by extension, Brian Harpole, because she implicates him, is going to have to come out and admit of their involvement in the Charlie Kirk assassination. That to me was like, okay, like everything that you hear forward is so compelling, so factual, so evidentiary that the U.S. government itself is going to have to come out and admit that, yeah, you're right. We were in on this. We did this crazy meeting that, you know, Mitch Snow just happened to walk in on at Fort Huachuca. But
critical point, Gary. I'll tell you where it is. It's in paragraph 40 of the complaint. The caption reads of the podcast. It says, she said, quote, after today, I do not know how this leads to anything other than a full confession from the government about their involvement in Charlie Kirk's assassination, end quote. Okay. I don't have the podcast clip here, but if I'm going off of the complaint, and that's a direct quote, that is not an opinion. You could argue, let's just run with this for a second. Let's just say hypothetically, well, this is an opinion, Raees. She's saying that she believes that the government this will lead to a confession that the government was involved in a conspiracy. Well, look at what led to that logical chain. It's the guy she's giving a platform to, Mr. Snow, who's coming forward saying that he entered a top secret meeting and swears that he was 99% certain that he saw Brian Harpole there. And here's, so Gary, I'm obviously trying to be a lawyer and look at it in an objective and neutral way. So one of the arguments in these situations where you have a witness who's coming to you, quote, a credible tip, that's what she says, is that you do get to rely on what the tipster tells you. As a matter of fact, anonymous sources are generally protected, right? Journalists can get protection over anonymous sources. The problem here is that his story does not add up. And the argument that, and again, these are allegations in a complaint. It's not argument, so to speak. But the story that's being conveyed here is this escalating manner in which Candace is no longer theorizing, but she's telling people, these are the facts, guys. This is the only story. Believe me, here's a credible guy who somehow managed to infiltrate Fort Huachuca and shouldn't have been there and overheard. That's not opinion. Those are facts, again, in my opinion. And I think Brian Harpole's lawyers did an excellent job identifying those points. So you asked me, you know, the top statements. So this section of the complaint right here that you've highlighted, it's on the screen. Let me just do an abstract for everybody. When you accuse somebody of conspiracy for murder, that's kind of a big deal.
Yeah.
Never mind that it was Charlie Kirk, and we don't have to agree on the merits of Charlie Kirk's message. The fact of the matter is, if you conspire to murder someone in public, that is probably one of the most serious crimes in existence. And so that's what we call, Gary, defamation per se. Meaning, Brian doesn't have to prove with that heavy of an allegation that he actually suffered harm. The law presumes that a statement of that nature was harmful. Does that make sense? So no, he kind of gets leverage on that. So that, to me, this cluster, and I in my notes I categorized sort of the worst statements. But the Fort Huachuca and the assassination conspiracy, that she had credible evidence. She even said, I searched the word fact-checked in this complaint, and I believe it's quoted. She said the word fact-checked. Okay, it's paragraph 37. Although Owens asserted that she had fact-checked Snow's account and that the facts are 100% honest. She provided no explanation of how this was done or what indicia of credibility supported her conclusion. The purpose of these statements was to assert, by implication, that there was a government conspiracy to assassinate Kirk and that Harpole was part of the conspiracy. And I agree with that. I do agree with that. Again, if this was in front of a jury, and go ahead, you were going to ask.
Really important there that you said assert by implication. So when you assert by implication, i.e., you're not directly accusing someone, that doesn't alleviate your potential culpability for defamation.
Correct.
Because that is kind of her MO, and that's a question to you. Like, that is what she does, because I hear all the time, well, she never directly said, you know, Erica Kirk or Brian Harpole killed Charlie Kirk. The other thing I hear too is, again, like, if you're saying that, if these people are saying, oh, okay, well, she never said that this person or this person directly killed Charlie Kirk, or even said that directly, but also even being part of the conspiracy, i.e., to cover it up, to have foreknowledge, is that also just as defamatory?
It is certainly, if you black and white, let's run with that. I like this, because if let's say on one hand, we all agree for the sake of this discussion that she did not say black and white, Brian Harpole, you killed Charlie Kirk. Let's just say, let's agree for purposes of discussion, she didn't say that.
Sure.
You can land in the same ditch of liability without those words. And I love this question because one of the points of analysis as a defamation lawyer, I tell this to clients all the time, the perspective that the law applies, the standard, is the reasonable viewer or listener. The reasonable listener. And if you convey enough information to an average Joe or Jane listening in the context of what you're talking about, the conclusion they draw is what matters. So in other words, it's the gist. You don't need to be you don't have to have scientific precision with your statements. And that's the actual standard. So when people say, well, she didn't say black and white, that Brian pointed a gun and shot the guy, or that it's foolish, because she so much as does say that. I mean, she talks about, she said black and white, that Brian knew, that he had knowledge that Charlie would not be alive.
Yeah.
And that she had credible evidence to substantiate these things. So once again, okay, a reasonable listener who's listening to this, critical, again, whether you agreed with Charlie Kirk's message or not, irrelevant. He was a public figure. He was speaking, and he was hotly debated. His topics were hotly debated. The topic of who killed him is certainly something that's open for public discussion, okay? The topic of ballistics is certainly open for discussion. The topics of motive is certainly open for discussion. But when you weave together a fact pattern and then say you have 100% fact check, this is not me making this up. I'm quoting it from the complaint. And the quote in the complaint purports to quote what she said on a podcast, which is, I've 100% fact checked this. And there is no logical conclusion other than a confession of conspiracy. You've stepped across opinion in my analysis. And this concept exists in the law, where you can, if you say a statement of fact and you couch it as an opinion, I'll give you an example in a second, but if you say a statement of fact, but you try to couch it as opinion, the law can penetrate that and say, no, you just said a fact. Like if I say, well, Gary, in my opinion, the AR-15 you have hanging on the back of your wall looks like the weapon that was used to kill somebody here in Phoenix last week. In fact, it's in my opinion, it's the same weapon, and I think you may have been involved in it. There's at least 4 or 5 facts in there. And I am allowed to give you the basis of an opinion. I can say, I believe this because. And I don't know, maybe I'll change my mind when I see discovery, because I'm giving you my analysis just based on what's alleged and what she said on her podcast. And that's what discovery is for. It's to change your mind. But I'm aghast at how she will defend on the basis of opinion, because her lawyers are going to have objectively, I'm just saying, a hard time with arguing that this is a statement of opinion that deserves protection. And granted, Gary, we have to go statement by statement, right? And that's why I'm picking out quotes in the complaint, because I can't throw everything in one bucket. And truly, I don't believe that every statement that Candace made is of the same level. I'm going with sort of the most egregious ones.
Sure. Well, let me ask you this. You know, we now know, as I laid out in a video just the other day, we now know that she actually had exculpatory evidence for both of her claims against Brian Harpole and Erica Kirk on the 15th that Erica Kirk gave to Candace. For instance, Brian Harpole's flight itineraries. And she never conveyed that to anybody until much later, till December 30th, as a matter of fact, when she did a X space. And by then she was just upset that, you know, Alex Jones had, I guess, published those before. Like, what kind of responsibility does someone like that, or maybe even like, how would the jury or a judge look at the fact that, you know, she hid this evidence while she was pushing a particular defamatory narrative?
The existence of provably false facts. Let me say that again. The existence of provably false facts cuts against the opinion, her opinion on where Brian Harpole was very, 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 very heavily. Okay. What I mean by that is, and there's a U.S. Supreme Court case called Milkovich that speaks to this exact thing, which is the opinion defense. And you can't say it's my opinion that Brian was there. If you have a document in your possession that says he was not, what you can say, and now this is a little gray, what you can say is, hey guys, I checked and there's a PJ that would have made it in 2 hours from where he was in Texas to Fort Huachuca, Arizona. How you land on a military base, I don't know. But my point is, or hey guys, in 8 hours he could have driven there, and there's an 8-hour gap. These are theories, those are opinions. But if you have a document that cuts against what you are saying is opinion, and you're basing your opinion on facts that are provably false, you have a problem. And her defense cannot ignore that. You know, if I'm on her defense, I am going to focus my defense on why there were facts that could be verified that support any opinion that I've made about the conspiracy. Okay? I'm going to go with laser precision, because plaintiff is going to show exactly what you just said, that she knew what she said was false and she did not care, and she selectively disclosed stuff to fit her narrative. And that's not journalism. I have a problem. Everybody should have a problem with that, whether you like Candace or not. Selectively putting facts out for millions of people, you should all have problems with it, because that's not what it's about, right?
Narrative building.
And look, at one point she said, correct me if I'm wrong, it's paragraph 68. I have this in my notes. She said on December 28th, let's pull this up here. By the way, can you just scroll back up to, there's an image right above, it's on page 34, actually. Yeah.
Okay.
I just want to, again, I love that they did this. So right here.
Yeah.
So paragraph 63 of the complaint says, on December 23rd, 2025, Owens posted to X, and she quotes this red alert light, Fort Huachuca confirmed. Quote. Now, that's a direct quote. All right. And the allegation is the body of the post claimed that she had proof that Snow was telling the truth about Harpole and contained a screenshot of what Owens claims to be the incident report from Snow's visit to Fort Huachuca. And what's beautiful is your own words being used against you, right? And so there's a direct quote. It's a picture of her X post. And I'm sure, you know, lawyers can't argue that this is not it unless it's completely made up, which it's not. Here it is. Find your favorite podcaster who joined the psychological operation to convince you Mitch was lying about having been at Fort Huachuca on 9/9, da-da-da-da. And she posts this picture. Hopefully everybody caught on to this. But look at what was said in allegation in paragraph 64. Owens published this post in attached screenshots to bolster Snow's story. However, a closer inspection of the screenshot reveals that it does not confirm the existence of a meeting, let alone state anything about Harpole's whereabouts. This screenshot does not place Harpole at Fort Huachuca and clearly depicts a cursor on the screen indicating that the screenshot was taken as the text was being typed. Upon information and belief, this cannot possibly be a true and authenticated, quote, incident report as Owens claims it was. And it's probably hard for your, and even in the complaint, it's hard to read.
Well, I have it here, as a matter of fact. Anyways.
Perfect.
But yes, do you want me to read this real quick, or at least the relevant portion?
Yeah, please do. It's important.
Not only does this incident report not confirm the material elements of her story, the material claims, but it actually contradicts her story, because she states that all of this occurred at 07:37 a.m. And I know this stuff off the top of my head because I went through it. But the complaint actually says, or this alleged incident report says, on Tuesday, 9 September 2025 at 11:17 a.m., the Fort Huachuca Military Police Station was notified that Daniel Head was notified of a suspicious individual of Southwest Border Mission Headquarters. OFC Navarro and Officer Johnston and Sergeant McClellan were dispatched upon arrival. The patrol spoke with CW2 Head, who stated that the individual entered the building with a backpack making concerning comments. The backpack was taken away and placed outside on the north side of the building, and called police station to report the incident. So they describe about 3 minutes worth of activity. Let's go crazy. Let's say 20 minutes of activity. And then they called the military police station at 11:17 a.m. So the earliest this took place was 11 a.m. because that does not account for 3.5 hours worth of activity there. So there's that. It goes on to talk about the statement. They got the driver's license incorrect. I don't know if, do you want me to continue reading, or is that good enough?
No, that's good. That's good. So importantly, so we're talking about formulation of an opinion and what's protected speech. In her statement on X, in the picture that's quoted in the complaint on paragraph 63, she says, I always believed Mitch's story of what happened on that morning because he supplied overwhelming evidence with metadata and timestamps. Now we have the incident report. Let me pause. Metadata and timestamps. This case, if it gets into discovery, is going to be nasty when it comes to data and discovery, because what she's saying is that he supplied her with documents and metadata. Metadata, right? For people who don't know, it's the forensic evidence that is technically you could fool around with, but it's data that tells things about the document, the creation of it, how long it was created, who created it, and timestamps. So she's giving statements that are factual. But what you just read, the question you're asking if you're an average reader is, well, does it confirm what she just said happened or not? You know, and by the way, where does this thing come from? Is it a picture of a computer screen? Did somebody type that? I mean, is this a legitimate incident report of something that happened on Fort Huachuca? If so, who gave it to her? Where did it come from? I don't know if the government flies like that.
The crazy element of this, Raees, is that the candy cult have been in my comments saying, "Oh my God, this is so true." There's like, there is no way that this is not authentic. But then they will take legal documents provided by whether it's the defense or the prosecution from the Tyler Robinson that are clear as day what's going on there, and they're like, "Oh, that's all fake. That's all fake." But this stuff right here, this is irrefutable evidence. And by the way, even if you accept this is only evidence that he was here. And if you do accept this, you have to accept that the 0737 time is completely, contradicted by the statement, by this document that you want to accept as fact. But
here's what I love about being a lawyer. I'm not going to speculate. I'm going to tell you exactly how this is going to go. That screenshot, the origins of it are going to be fished out. So what we're seeing in the complaint is a screenshot of a screenshot. And it could even be a screenshot of a screenshot of a screenshot. Okay? But the point is, somebody had something on a screen, took a picture of it, sent it to Candace, and Candace took a screenshot and posted that. Forensically, okay, this does not become evidence, or I should say it this way, this is going to be very hard to introduce as evidence of anything until we know who wrote it, they testify that they wrote it, or there's some reasonable basis to say, Your Honor, we can't because it would compromise some national security issue, da-da-da-da-da. By the way, that argument doesn't always work in these civil cases. But my point is, this is not evidence in and of itself, okay? It could be manufactured, but before it has any legal weight, there are hoops it has to jump through. And this is what the average person may not understand in how this litigation stuff works. She's claiming it's evidence. She's telling people, and Candace is sophisticated. She's talking about metadata. She's talking about timestamps. So what she's telling her readers and listeners is that, believe me, I have vetted the facts. What the defense is going to do is they're going to say, give me those facts that you say you vetted. Let's see where. So this is going to come out in evidence, right? If I'm Brian Harpole, I'm already making a list of documents I'm requesting in discovery. This is the first one.
Now, let me ask you a question regarding that specifically, because Stu Peters, I don't know if you're aware of who he is, but he was actually issued a preservation order by Brian Harpole's attorneys. How much weight? And he was basically like, you can't tell me to do anything. F you. It's like, how much weight does a preservation order have? And is there any repercussions if he does decide to delete everything and try to not turn over any, how does that work?
So two things. If there's an order to preserve, it is absolutely an order from the court, and it's contempt to violate the order. But even in the absence of an order, like in my cases, it's very standard that I send a preservation letter to not only the adverse party, but to potential witnesses, right? To people that I know may be involved and get called as custodians of something. And yes, it would be, if a party deletes, so if Candace or any of the defendants named, or Brian himself deletes anything in anticipation of litigation or after the lawsuit's filed, it is absolutely sanctionable. It could be contempt of court. It could absolutely derail their case. We saw this in we saw this battle in Amber Heard, Johnny Depp's case. We see it a lot in celebrity cases. Judges do not like, and the jury will get to hear an instruction if it happened that we don't know what this person had, but we believe that it was evidence against them, and that's why they deleted it. And if you're a person on the jury and you hear that, that sounds terrible. Okay. Yeah. So if you're telling the truth, you have every reason to preserve evidence. I'll say it that way.
Oh, that makes sense.
In terms of, we were going down sort of the list of some of the most egregious statements, and
was the one we were headed to before we sidetracked on that one.
It was 68, paragraph 68.
Also on December 28, 2025, Owens posted to her X account that Brian Harple ignored her texts but submitted his irrelevant flights. Mitch felt very certain he saw Brian Harple exiting the top brass meeting around 7:30 a.m.
And then here's her entire repost.
She says, reposted with new information, totally agree with you on the below. While I was never fully committing myself to rely on Mitch's memory, the frankly bizarre misinformation campaign, which now includes his ex-girlfriend's estranged sons and periodic emotional breakdowns from Alex Jones, leads me to believe we now need solid information on the whereabouts of all mentioned so we can move on. Here's where we're at. Brian Harple ignored my text, but submitted his irrelevant flights through Andrew Colvett to a YouTuber. I wonder who that YouTuber is. Mitch felt very certain he saw Brian Harple exiting the top brass meeting around 7:30 a.m. Erica Kirk, for no reason at all, she submitted her irrelevant metadata via Andrew Colvett in a YouTuber, guilty as charged, as proof of her whereabouts on the 9th, which was never a topic of discussion. Mitch felt very certain he saw her on the 8th at a hotel on the base. Important to note, this sighting was not at the top brass meeting on the 9th. Could be entirely unrelated to the meeting. Mark Amadei shared an actually relevant link to his House Committee stream on 9/9. He indeed misses the first two roll calls and does not vote until 3 p.m., but many people believe they see him on camera before the roll call begins at 58 mark in the video.
Let me pause you right there, Gary. One of the things that's staggering, can you scroll down to paragraph 69 of the complaint?
Yes.
Okay, this is the context that Brian Harple's lawyers are giving right here. It says, Owens again admitted that she viewed Harple's flight logs, but nevertheless reaffirmed Snow's claim that, quote, he felt very certain he saw Brian Harple at Fort Huachuca. Sensing, and then paragraph 70, sensing that her Fort Huachuca theory was slowly falling apart, Owens pivoted back to spreading misinformation regarding Harple's fitness as Kirk's head of security and his role in Kirk's assassination. So why this is relevant to actual malice is exactly what we were talking about earlier, is if you were in possession of records that contradict the position that you're taking, even if you couched your statement as an opinion, but you are in possession of records that you didn't disclose or that absolutely alter that opinion, now you're treading into false statements of fact. And so Brian Harple's lawyers correctly highlight that how is she calling Brian's flight logs as irrelevant? How is she saying it's irrelevant? And she's saying it's irrelevant only because allegedly Mitch saw him or saw someone that he thought was Brian. But that's for the listener to decide. Right? So in hindsight, if I was Candace's lawyer and I was trying to advise her on how not to get sued, I would say something like this. Guys, there's somebody here who claims he saw Brian Harple. I'm going to give him a chance to say what he's going to say. We don't know if it's accurate or not. And then here comes this guy, Mitch Snow, who thinks he's the son of that murderer whose name is now leaving me.
Oh, yeah, killer.
Yeah. Who claimed that his wife attacked him with the hammer, even though he's the one with the hammer in the video. I mean, I could go on and on. It's pretty crazy. But my point is this. If I'm Candace Owens' lawyer, I'm saying, if you want to have Mitch on your show, let him talk. You do not take a position on whether what he is saying is truthful or not, because you also have flight logs. And if somebody is saying, I saw you in Disneyland, and somebody else is saying, here is my receipt, I was having dinner at Carbone in New York City, that's a problem. But that's not how it played out. So look,
defended it for weeks and weeks, and really to this day, like she hasn't ever said, "Oh, he could have been wrong." She's hedging a little bit, but it's still, she still has it out there as essentially as fact, and it's unbelievably wild to watch. One of the things that I've heard people say that I would like you to address directly is, well, she gave Brian Harple a chance to clear himself. She sent him a text on the 17th, even though she had his number the entire time. She says that. The Fort Huachuca story aired on December 9th, the original, that implicated and defamed Brian Harpool. She did not, by her own admission, text Brian Harpool till December 17th, after I'm assuming Erica Kirk told her on the 15th that he was going to sue her. Does that alleviate her of any culpability? Does Brian Harpool have any responsibility? Let's say she called him and tried to text him on the 7th, but he didn't answer because he doesn't like her or whatever else. Like, does that body of facts alleviate her of any culpability in this?
No. And I tell this to people all the time who say, I tried to contact someone and they didn't respond, and so I'm sticking to my story. The absence of a controverting version of a story doesn't mean your version is correct. It's a logical fallacy.
Yeah.
If you don't have the other half of the story, then that's what you say. You say, I don't have the other half of the story. Brian is not and was not at any time, just like most plaintiffs who sue for defamation, under an obligation to send all of the information they have to clear their name. Not under a legal duty to do that. And certainly it will come out in discovery if they sue for defamation. But my point is that usually the right way to do this is to just say exactly what I said. We reached out for contact. We didn't hear back. Here's what we think, rather than saying what she said. That's how smart people do things. We haven't even really touched this second category of accusations of criminal murder conspiracy, which is, it starts around paragraph 83 and 84. So this next section of the complaint, right, this kind of goes through the whole assassination conspiracy Fort Huachuca thing. And she doubles down, according to the allegations. But where things get extremely spicy, and I say that from both a discovery, what she's going to have to prove, and what her defense lawyers are going to have to figure out how to overcome, is this sort of second category of direct accusations of criminal conduct and murder conspiracies that the story kind of starts on right here, what you have on the screen. So this is within the defamation count against Owens, Candace, and George Tom. So interestingly, this defamation count does not include Snow. This is directed specifically at Owens and her production company, Candace. And that is beginning in October 2025 and continuing through the filing of this complaint. Owens directly and through Candace Owens LLC and George Tom's Inc. has and continues to publish defamatory remarks accusing Harpool of foreknowledge of involvement and cover-up of Charlie Kirk's assassination. These accusations also imply criminal behavior. And then paragraph 84 and 85 kind of outline the basis for that allegation, which any reasonable reader, Gary, is going to probably read this as saying, yeah, this is a conspiracy to kill. Remember we talked about earlier, like, does she have to say that this guy definitely did it? No. Because she said enough statements for people to connect the dots to say that Brian was involved in a conspiracy. And these are the specific allegations. The lawyers did a great job. Brian's lawyers did a great job itemizing this for us to read after the fact. But here it is, right? Look at item B. After today, I do not know how this leads to anything other than a full confession from the government. We bring you an explosive interview with what may be the lone eyewitness to a mysterious top brass meeting which occurred on Fort Huachuca the day before Charlie's assassination. She publishes Mish's false account. She says it's compelling, and she says she was given travel logs. But again, we just looked at the fact that she also publicly stated that the travel logs were irrelevant. And then, I passed this allegation. It was on paragraph 74, but she says, let's see, I think it's mentioned here too. Look at paragraph 74. This one's Okay, there's statements of fact and there's statements of fact, right? Paragraph 74. Owen stated that's what I mean when you lie a lot. And when you're planning things you're not supposed to be planning. You don't think through every detail. Yeah, as in the next day, if you expected Charlie to make it to September 11th, you would have been communicating about what he was doing up at the Charis Bible College, end quote. And so, this section of the complaint, paragraph 33, tees it up too. Paragraph 73, right before this. But she's basically saying that Brian knew, that Charlie would not make it to the next day, which is why there was zero planning. That's a hell of an accusation.
Yeah.
Right? It's directly implying knowledge. I think that's going to be another difficult one to overcome.
Wow.
And by the way, I haven't seen all of Brian Harple's post-lawsuit discussions on this, but he's commented on the accusations pre-lawsuit, didn't he? Didn't he come out on a podcast or two and sort of explain?
He came to Sean Ryan's first, and then he and I did an interview right here, and we went through literally everything. And between, one of the things I did was that when all the questions that Sean Ryan didn't ask that people wanted, I asked him. And so, yeah, I mean, he did 2 podcasts. Those are the only public statements he's made on this. And, he basically said, hey, this is what happened. I know a lot of people are saying something otherwise, but this is what happened. This is what took place. And, so that's another element of this that I'd like to hear your opinion on. Would the court, because like you said, a public figure is going to be considered a higher bar, a higher standard. Sounds like everything that you talked about, that he more than clears that bar regardless. But would the court likely consider Brian Harple a public figure because he did go on 2 podcasts and make statements about what happened?
Yeah, good question. I do not think under Tennessee law that he's going to be considered a public figure. And I actually looked at some case law on this, and this is something I was researching because I was just genuinely curious, right? If I'm Candace, what I'm arguing. And generally speaking, right, 2 podcast appearances, which were only made to rebut the accusations, is not going to qualify you as a public figure. He would have had to bring himself into a controversy first. The controversy arose, then he commented. He didn't create the controversy. And so I don't think under Tennessee law, he's going to be considered a public figure. What we would call him a limited purpose public figure. That's the framing. I think he's a private plaintiff. Okay. I don't think, I don't think he's a public figure. But regardless, he is suing a media, what we call a media defendant. So actual malice. And this is why Brian's lawyers did what they did by repeating this theme in the complaint that there is knowledge of falsity. Hey, they're prepping the judge that just in case there's a motion, this anti-slap motion that we talked about. And by the way, we haven't gone into this in grave detail, but Tennessee has this statute. Most now, majority of United States have this. It's a function of state law. And it's a very pro First Amendment defense-oriented statute. And that is this. If you sue somebody for defamation, and it is either a statement that is about a public controversy, so for example, the death of Charlie Kirk, and it is purely opinion, and it's something that is, let's say, newsworthy, and it's within the scope of First Amendment, the defense can file a lawsuit, can file a motion to dismiss your complaint and get attorney's fees right at the outset of your lawsuit. And it's dangerous, right? Because California, Nevada, Texas, New York, Washington State, these are states that have some of the best defense-facing anti-SLAPP statutes. Again, that means if you're a plaintiff and you're suing in those jurisdictions, you need to be very, very, very careful when you allege your complaint that you've alleged sufficient evidence just at the complaint phase. This is unlike a breach of contract case.
Right.
And the reason why that protection exists for defendants is because we're concerned about the First Amendment. We're concerned about people being sued for participating in a public discussion, people like yourself who are just trying to put information out there, who are developing opinions and theories. We don't want to silence them. And that's what the anti-SLAPP statutes are designed to stop. Now, I will say this. Sometimes judges get it wrong. And sometimes a case gets dismissed pursuant to anti-SLAPP that shouldn't have been dismissed. You saw this during the Me Too lawsuits where people were saying, I'm being, for example, falsely accused of sexual assault. And sometimes those cases would get dismissed, rightfully so if you're falsely accused of sexual assault, right? But at the flip side, it's dangerous because what if somebody's right and they did get sexually assaulted and they did speak out about it and they got sued and the case got dismissed under anti-SLAPP? So judges don't always get it right. The system is designed to protect what's obviously free speech. But I know Candace's lawyers, if they're listening, and they will watch this at some point, and I do a lot of this work, they have to be studying Tennessee's anti-SLAPP statute. And it does exist. It's one of the states that have it. It's not as well developed as other states. There are questions because this is now in federal court, and why that matters, not to get too technical for the audience, but there is a jurisdiction question as to whether anti-SLAPP applies in a federal diversity case. In a federal diversity, it means that the plaintiff and defendant both are in different, reside in different states, and that the dispute is over $75,000. So you can bring that kind of a case in federal court, right? The idea is to have a judge that is a little more neutral and removed versus a state court judge who might favor somebody who has a company registered in Tennessee, like Candace. So plaintiffs brought this in federal court in Tennessee, and there are questions as to whether anti-SLAPP even applies. Okay, so not to show the cards to Candace's lawyers too much, but hey, I'm being a neutral, objective person. There's questions on whether it applies. The problem for her and the defense period in this case is, what did you have? And does it cut against the statements that you told the people were not lies? You accused Brian of lying. You said Mr. Snow is telling the truth with certainty. But are there documents in your possession that show that you knew, or at least you questioned? And this distinction is important, Gary, that knowledge of falsity is hard to prove because you have to get into somebody's head. And
Sure.
We talked about the CNN case, right, with Zachary Young. The way they were able to prove that is because there were emails where CNN was engaging in this back and forth. The producers were questioning. I don't remember if it was emails or texts, but there's stuff in writing which basically was like, hey, should we publish this or not? Maybe we should double check this. How do we know this? How do we know that? When you have something in writing that shows that, that shows you're entertaining doubts, right? It shows that you're questioning the truthfulness. That's all you need to show. You don't need to show that Candace actually knew for a fact that Brian Harpole didn't do it or wasn't involved in a conspiracy. You don't need to prove that. That's really, really hard. You just need to be able to prove that a reasonable person looking at this could conclude, based on the evidence, Candace's testimony, metadata, documents, text messages, emails, that, you know what, she did doubt her theory of this case. And again, the lawyers did a good job of showing escalation, that this is what she was saying in December. This is what she was saying on this podcast. And she started pivoting her theory when things didn't make sense to her. That's part of their case. These are things that lawyers think about, that the average lay person looking at a public lawsuit like this wouldn't think about. Is she pivoting? What facts do I have to support the defense that there's a high likelihood that we're going to lose? And how do I get ahead of it? Look, man, we've got Candace Owens getting sued for defamation over the Bridget McCrone thing, and I tend to draw parallels. We haven't talked about that case, but I think Brian Harpole's lawyer should study that, the docket in that case, how that case is relatively early. Also, there's some motions to dismiss going on in that case. But I think you study that to determine Candace's mental state when she's making these claims, and whether she really knows what she's talking about is a lie or not.
Well, and then, after this December 18th interview with Mitch Snow, myself and other content creators, especially guys in the military, look, one of the biggest problems is like, hey, you're accusing the military, and by the way, a conventional unit that is tasked with, advising and assisting Border Patrol, Joint Task Force Southern Border. You're accusing them of participating, planning a assassination of a U.S. citizen on U.S. soil, which is preposterous, if anybody knows in the military. So you had all these people come out and saying, hey, and by the way, she also clearly indicates that even people within her inner circle were saying, look, distance yourself from this guy because he's not telling the truth, and here's why. And I laid it out, other people laid it out. Is that damaging to her as well, even though she just completely rejected all of these people saying, hey, this is impossible, this is not how the military works, this isn't what takes place? Is that going to be weighed, is that going to be one of those things that it's going to be taken into account as well?
It's going to be taken into an account because it impacts the question of knowledge of falsity and reckless disregard for the truth. Did she entertain serious doubts? Is she doing homework on what these people are telling us? Did she text her producers saying, hey, I heard this may not be correct? That's discoverable. All those communications, again, this is what sucks about being a defendant in defamation cases, at least in defamation cases that get to discovery. Those communications, if your defense is, their opinion, and I did my homework and I was not reckless, they're probably going to be discoverable. So all of her text communications and logs with producers and people who are on her team who are trying to vet this stuff, all of that should come into evidence. By the way, there's something else you touched on that I don't know that people are thinking about, which is she has really set this up for other people to sue her for defamation as well. And I kept thinking about this. I'm thinking, if I'm Candace, I'm waiting for the next shoe to drop. Who else is going to come out of the woodwork and say, because look, there's going to be discovery of who else was at these quote unquote meetings and who else conspired. Remember, her accusation is the federal government. Well, the federal government is not a boogeyman ghost. It's made up of people. And so apparently there are people who were acting jointly with Brian. Who else was in the security detail? Who else was at the Fort Huachuca meeting? And if I'm those people and I'm thinking I'm going to be a witness, I'm probably also going to sue for defamation, because it's going to come out and it's going to be all over the news, and Candace is going to double down probably.
Yeah, she does tend to do that without a doubt. I don't think she can afford to admit she did anything wrong at this point. This is kind of got lost in the sauce a little bit, but I think it's interesting to hear your thoughts, maybe real quickly. Like, what do you think? How do you think the case is against Mitch Snow himself in all this?
Yeah, so Mitch Snow, it's interesting, and there's a separate claim alleged against him. When you take a position that you were there, that you saw something that and you are contributing to a conspiracy to commit murder, if not murder itself, there is absolutely culpability, right? Because he's either lying that he was at this meeting or not. And if it turns out that it's a lie, he may have more blood on his hands than Candace, because he can't say I was relying on Candace. Candace can say I was relying on Mitch Snow. So the allegations of defamation, there's a count against him specifically on page 58. But he's publishing statements that I was there, I saw this person, multiple lieutenant colonels. He described these meetings. He later published these statements on her podcast. So he has independent liability from Candace, okay? He talks about high-ranking officials, the head of security being there. According to Snow, he says he knew it was Harpole because, quote, he has a gift for recognizing people. So apparently Snow has a gift for recognizing people. And he said he saw, quote, someone with the same mannerisms, crick, his neck, waxy looking face, which is a really weird way to describe somebody.
It is.
His haircut, and that it was 95 to 90% certain. So when Brian, if Brian can prevail in showing that he was not present, that is defamation right there. Because he is discrediting. Let's remember, let's zoom out for a second. Who you are as a plaintiff suing for defamation matters, because you're suing for reputational harm. If this guy had big security contracts, which I imagine Charlie Kirk didn't just hire some bozo clown from Craigslist. He probably hired somebody who had a reputation, not his cousin's brother kind of thing.
Sure.
And if people believe that you utterly failed at protecting someone, and in fact, even worse, conspired to kill them, you're probably going to lose a lot of money. Okay. And even if he hasn't lost a contract, the law is going to say your reputation has fallen many, many steps. The reason that is relevant is because juxtaposition who this Snow guy is with who Brian is. And the jury is going to have to decide who's telling the truth. Because I'll say it again. Mitch was either lying about being there himself and what he saw.
It's just a matter of the element, the material elements of this stuff. I think he was there, and I've always stated that. Like, I think between the metadata that he provided, which was probably hotel receipts or he sent photos at the location. So he was almost certainly there, I think. But that's irrelevant to the actual claims.
Well, as a lawyer, I look at it. I'm trying to make an objective evaluation. I say, was he there? I don't know. It's an accusation that.
Oh, Brian Harpel was there. Whether Brian Harpel was there.
Correct.
Yeah.
So either Brian Harpel was there and Mitch saw him or not.
Yeah.
Okay. He's saying with 95 to 99% certainty, and he's saying he has this tenacious quality of being able to identify people. So Mitch is not saying, hey, I think I saw somebody that matched. That's how you and I would say. I went to the store. I thought I saw from the backside this guy who was like 6 feet tall and had red hair and looked like Gary's build. I'm not sure, though. He's saying 95 to 90% certain. Remember, in a civil case, it's not beyond a reasonable doubt. It's 51% likelihood. It's more likely or not standard. So
that's important.
Credibility is going to become an issue. And by the way, we don't know yet because no attorneys have appeared on behalf of Candace or Mitch. I checked the docket before I got on today, and the docket doesn't show who's appearing as counsel yet. It doesn't mean that no one's picked up the phone and called Brian's lawyers and said, we're going to make an appearance. That's what we call it, a formal appearance. But my point is, we don't know if Mitch and Candace are going to be at odds with each other. Because part of her defense is throwing Mitch under the bus. And so if I'm a lawyer, I'm probably not going to jointly represent them. And if Mitch turns out to be the type of weirdo that we all think he is, and I'm struck. I really didn't want to say that, but that's my honest opinion. I'm looking at it objectively.
Sure.
I don't want to represent him. I'm telling Candace, I know you got him on the show, and I know you believed him, but you're going to have to throw him under the bus. If shit hits the fan and documents come out and the metadata is wrong, you're going to be on the same side as a guy who knowingly lied to you and you relied on it.
Well, the inverse is going to be true as well, right? Like his lawyer is going to be like, hey, look, you got to throw her under the bus. And how does that dynamic play out?
I think that he has more to worry about. Because here's why I say that. He's coming forward and saying, I saw somebody. He's coming forward and saying, this is true. Candace, rely on me. And while Candace has done some diligence, she can claim, and at least as part of her defense, look, I really believed objectively this guy's story. It made sense to me. Here's the reasons why. 1, 2, 3, 4, 5, 6, 7. Mitch does not have that. What did he rely on Candace for? as part of his story? Nothing. He got on her podcast and told a story. So he doesn't have a reciprocal reliance defense on a story narrative because he's a source. And he's a source for what Candace relied on. So I think Candace is the one that has a better, if anyone's going to step on somebody's neck, Candace should step on his neck, and Mitch doesn't have the same benefit here. And look, maybe we're all really stupid, and Candace designed this beautifully and said, look, I know that there's a chance that Mitch was crazy and wrong, but I've papered this up enough, and this is lawyer talk. I've papered this up enough that if I get sued for defamation, I can point the finger at Mitch and say, look, I believed him because he sent me all this. The Fort Huachuca incident report, he said he was 90%, 99% certain. He took a lie detector test. We don't know these things. It's subject to discovery.
Sure.
So I will be watching carefully to see if they end up getting the same lawyers or not. I think that'll tell a big part of the story and how they're going to try to get out of this.
All right, here's the part that no one likes. How long, if this goes to trial, how long do you think it is before trial? And then also, I'd also like to ask you a little bit about the Macron case regarding that as well. And I know these things take longer than people wish they would. What's your analysis on that?
So two things with respect to trial. First of all, defamation cases tend to be front-loaded. There tends to be a lot of motion practice. So there's probably going to be some sort of defensive motion to dismiss. I talked about anti-SLAPP is sort of a Hail Mary defense to dispose of the case up front and say, it's protected speech, we're out. That alone can cause, it could dispose of the case within 90 days or so. But some motion is going to likely come up front. I don't think they're just going to file an answer to the complaint. I suspect, and this is federal court, which tends to be defense friendly. I suspect that this is a 2 to 3 year throw. And I think that's going to happen because there's going to be government officials that likely get drawn into this. There's going to be a request for protective orders. There's going to be a dispute over forensics and search terms and metadata. That's a lot of stuff. And district court federal judges are usually better equipped than state judges to deal with those issues. They'll have an opportunity to get into a settlement conference and talk about the merits of each party's case before it goes to trial. This is a 2 to 3 year road. My favorite part about these cases is the discovery, because you just never know how your client's going to testify under oath. Everybody seems polished until it's go time. And then something comes out in a deposition or a text gets leaked and the dynamic changes. So unfortunately, or fortunately, everyone's going to have a lot more content for some time.
That is wild, to say the least.
Yeah. So you asked about the Candace Owens, Bridget Macron case, and so for those who don't know the ins and outs of this, right? Bridget Macron, the first lady of France, if you will, is suing for defamation because Candace Owens basically said Bridget Macron is secretly a man. She also accused her of being part of a groomer ring and having an incestuous relationship. She said she was part of the CIA MK Ultra program, part of CIA journalist assassination attempts. It's grown significantly since, I think, March 2024 or sometime early 2024. But Bridget's team sent to Candace her birth announcements, childhood photos, family records, court rulings, marriage records, which show that she was a woman, legal letters, proof that sources that Candace had were fraudulent. And Candace, as most grifters, ignored the objective facts. And so now there are, there's motion practice. I don't think there's any dispositive rulings. I was checking, but you have a similar dynamic here where the defense, Candace this time, is going to say, well, Candace, just like in Brian's case, I guess she would say the same defense that, hey, standard is reckless disregard for the truth. Can't prove I was reckless. Bridget, unlike Brian, is a public figure. There's no question about that.
Right.
Extra hurdle. But the interesting thing is, Candace keeps saying, well, just give us your DNA and disprove it, right? Give us your DNA. And I'm like, it's not exactly how it works. You as the plaintiff have the burden. Macron is the plaintiff. They would have the burden to prove their case. And you have the burden, Candace, to prove that your opinion was an opinion and it wasn't a false statement of fact. My opinion on this is she should settle that case. I feel like you're fighting a minister of a country, their spouse. You kind of don't have unlimited resources for that fight, and they sort of do. And so I don't know. Like, I thought it was funny at first. I'm not gonna lie. Like, I took it as hyperbole, and this is the topic of an SNL skit. Like, okay, she's a man, ha ha ha. She looks masculine. Okay, we got it. And Gary, look, there's some really weird facts about Bridget. Like, she was a teacher for her husband. There's a 15-year plus delta. Seems a little sus. She could have stopped there. I think she has enough. I think let me say it this way. I think plaintiff is going to be able to prove that Candace was in possession of documents that refuted her statements, and she made them anyway. And her defense will.
Go ahead. I'm sorry.
No, and Candace's defense will turn on whether she believed the record she was in possession of or not. I think that's what's going to happen.
Yeah, I mean, and even going back to what you were saying, like, if Brigitte Macron did send her DNA, why would she accept that? Like, you have a whole state-sponsored, you have a whole state that you're going up against. Why couldn't they fabricate that as well? I don't think she would accept any evidence, and that's what we're dealing with here today too, between this case and every other element of this. The fact that Erica, there's no evidence that Erica was involved. There's no evidence of all these other people they say are involved. The French Foreign Legion, we have no evidence of that. We have no evidence that the French actually put out a hit on Candace Owens. All we have is her words in the ether. But no matter what evidence is presented to these people, and Candace specifically, all these people led by Candace, she just rejects any evidence that is counterproductive to whatever narrative that she's going with. And that's and when you're rejecting, that's the frustrating thing, I think, for me and a lot of other people out there. It's like, I feel like I'm taking crazy pills, because it's like, okay, I believe that Erica Kirk and all these other people were involved in the assassination of Charlie Kirk. Okay, give me evidence to say that. Well, I don't really have evidence. Or, well, she wore sparkly pants. That's really all you need. And you're like, okay, well, we have these charging documents that enumerate voluminous evidence, so much evidence that the defense needs additional time just to go through for the probable cause portion of this. So we have video evidence, DNA evidence. Like, no. All of that's fake. All of that's, like, we have this multi-agency conspiracy that involves hundreds of people. It's all fake. Tyler Robinson is a patsy. And you're like, oh my God, like, there is no logic or reason that's being applied to this. And this is where it gets frustrating to even attempt to have these good faith discussions with people that are on the opposite side of this with you from, a social media perspective, or just a public discussion on it. And it's just, I don't know. It's frustrating too, because it's like, man, it's frustrating to see how many Americans are so easily duped. It's frustrating to see, like, how many people will believe something just because it's said without any evidence, or with such circumstantial evidence that you are led to believe something that's more direct. Like, okay, well, I don't like the way she cried. She cried too much. She's appearing too much. She wore sparkly pants or fireworks. Okay. The next thing we go into is that she conspired to have her own husband killed in front of in front of the world. I don't know how you get there. I really don't.
I'll say this about people believing things when they shouldn't. So a big part of my practice is vetting information on one side or another, right? If I'm the plaintiff and somebody's hiring me to sue someone for defamation, it's because somebody said something false and I need to evaluate the case. On the defense side, I'm evaluating whether the statements were protected opinion or not. Here's my message to people who are the consumers of information. I think consumers of information today, 2026, need to do a better job of discerning what is being said, but without a political lens. And this is what makes this very, very hard, right? Is as a lawyer, I don't look at someone, I don't care, frankly, if Candace is right, left, MAGA, liberal. I don't care, because I'm evaluating the truthfulness of a statement. And I think the first mistake people make is they automatically look at what shirt someone's wearing. Are they red shirt, blue shirt? And that is absolutely the incorrect way to look at things. There are people who want you to look at things that way because it's easier to control your conclusion if we can force you into a box and make it predictable. So one of the things, and I tell this to everybody, is do your own assessment, do your own homework. And it's hard to be objective. It's much easier to judge somebody by the way they look, the way they appear, how they speak, whether they're red shirt, blue shirt, green shirt. And that's a mistake. And I think today, people who have platforms have taken advantage of that. And because they know that, you know what, whatever I say, the people who listen to me, because they're so much for this cause or they're so far on this spectrum politically, they're going to just believe it. People know that. You don't have to go further than reading comments in certain posts to know that. And they immediately attack the opposing viewpoint. As a lawyer, I'm an investigator first. Even when my own clients hire me, we go through a process of diligence to determine, does this case stink? Is it a skunk? Are you in the wrong? I don't just take your money and believe you. It doesn't work that way. That's one of the beauties of litigation. Unfortunately, average consumer of information on Instagram or social media or YouTube is not a litigator, is not an attorney. They're looking at it from the lens of quick information, convenient conclusions, and that's part of the problem. It's not just the people who are talking, who are definitely a source of the problem. It's the consumers too. I mean, I do want to make clear though, I've never been a huge fan of big box media. I like independent bloggers, people like yourself, people who are asking the questions on my Instagram channel. You know, I do short form videos right now and I ask questions, and I'm usually, of course, I have made up my mind to some degree, but sometimes I haven't. But I like to ask the questions. People should look at me like, you know what? This is a lawyer who practices in this realm. They shouldn't start trying to dice me up to, oh, I wonder what religion he is. I wonder what, where he stands on the conservative versus liberal perspective. That automatically flushes objectivity. And that is very difficult. Again, most people fall in that bucket where we react to who's speaking rather than what they are saying. And whether it's Candace, whether it's Tucker Carlson or Kanye West or anyone else.
Yeah.
Rational people can reach a middle ground so long as you don't look in the extreme ends of communication and you don't judge the message by just who is speaking. We've fought countries, and you know this, we've fought wars and we've sent military into countries on false premises, and it still happens to this day. And it's only later where we discover that it was complete bullshit. Even though at the time in the halls of Congress, people were on the right track, asking the right questions. But it takes just a few people to just believe the talking heads on whatever the issue is to say, yeah, I'm going to turn off my analysis brain. It's too easy for me to just agree with what this guy's saying because I just believe this guy and stop thinking. And we are where we are today. And unfortunately, our country's in optically, from the perspective of unity, we're not a very united country right now. And add to it the headlines and the fake news, and it's a misinformation mess.
Yeah.
And the reality is it's easier to control people when it's a mess. And so it's unfortunate. You know, I'm in the information game just as much as anybody else on a day-to-day basis. And for me as an outsider looking at it, the issue of believability is a problem. Now add AI and fake news, and that's a crazy cocktail.
Well,
I mean,
you know, you touched on something that I think is at the heart of this entire issue. And that is, you know, we have a government that has abused our trust. And then we also had a mainstream media that has abused our trust. And that is the argument that I hear from a lot of these people. It's like, okay, the US government, you know, it's this false equivalency where it's like the US government told us that there was weapons of mass destruction. That was a lie. They told us that, you know, COVID this, COVID that, that's a lie. And now you want me to believe this charging documents against Tyler Robinson. So pretty much almost by default, we're going to believe this other narrative. And I think that is the challenge of trying to figure out through, and the only way that, and this is one of the things, like, I don't trust government. I sure as hell don't trust social media personalities either. And because the government's lied, they don't lie all the time. If they just lie all the time, let's just empty the prisons. All of those prosecutions of murderers, rapists, or whatever else, just empty them out because it was all a lie. But I can tell you the social media personalities, they're lying too. And, you know, the way that you kind of sort through that, or my advice, and I'd like to, you know, I think you hit on some of this, but it's like, you have to look at it from, you have to judge every single situation on its own merits. And, you know, the U.S. government's going to lie about this one issue today, and then over here they're going to tell you the exact same truth, exactly the truth. And like the only way that we can come to a reasonable conclusion is through logic, evidence, and not just default lazy thinking.
And I 100% wholeheartedly agree. And something that look, I'm not a big fan of politics in general, because for the reason I just said, if you color someone blue, red, green, purple, whatever, you start to lose objectivity. And if you want to make a decision as a citizen of the United States, of a resident of the United States, as a business owner, as a lawyer, as somebody watching Candace Owens, you need to be rational and an independent thinker. You can't just hit the stamp and say, well, this is how she is, so this is how it must be. It goes all around, right? There's been an erosion of honesty and truth by content creators. There's been an injection of motive-based information. And look, let's be clear. Big box media has always had motives too. Like if you go into the shareholders of these companies, there's only 4 big media companies left. They're in it for profits, other than independent, you know, radio and news media. And to talk about trust with the government, and any government, this is not a stab at who's in power. We could go back 60, 70 years. Yeah. You know, at one point, the United States Surgeon General was effectively promoting and enabling tobacco and tobacco use. And you know, in the military, your ration gear would have a cigarette in it. And we poisoned our soldiers, and we made it okay to poison people until independent thinkers said, actually, you know what? We think R.J. Reynolds and tobacco has been abused. Maybe we should ratchet that back. And I'm old enough to have seen the slow erosion of tobacco advertising in the back of magazines and billboards. And Joe Camel was the coolest guy. Everybody wanted to be Joe Camel, right? And so how quickly we lose sight of history. Every government always has an incentive to tell you things, to control you. I don't care who is in power. Yep. It's your job as a citizen, as a consumer, to be smart and try to hunt and look past it and say, I can understand what's going on. I see the interest groups at war. In America, we are a democracy, but we've become really more of a corporate oligarchy. And money and influence and power has bled now into even Instagram as a platform, and censorship. So if you think like that, even if you don't make the the perfect decision, you will be a better consumer of content online, in my opinion, as a lawyer of 16 years doing this.
I think that is sage advice, to say the least. Let's hit a few questions, and then we'll close this up. Truth Matter says, I'm glad you brought Drake up now. Questions for Beard. How come Drake never sued Kendrick Lamar directly?
Yeah, I think the reason he didn't sue him directly, it's a great question, is because Universal Music Group owns the rights to the music. Kendrick Lamar doesn't. And if the relief you're seeking is to stop the publication of the song, which I think was part of it, then you're going to sue the music, the licensing company, Universal Music Group. It was also part of Drake's theory that Universal Music Group was playing favoritism because he is also signed with Universal Music Group. So it played into the narrative of sort of choosing sides, if you will. So,
fair enough. I already know the answer to this question, but there's a lot of, I'm sure there's people out there wondering, can the military sue her?
Yeah, so the government doesn't typically engage in private lawsuits. You know, they do things like, you know, they get involved in RICO cases, or if you wasted government funds. But so the government wouldn't sue, but a private person could sue in their capacity as a private individual if they are being alleged to be involved in the cover-up of a murder.
Yeah, like those lieutenant colonels at the meeting, if whoever he saw. This actually plays into a bigger question too. Gary, can you ask him? Owens called Erica a black widow. Isn't that definitively inferring she murdered Charlie? She's made other statements on that. Based on what you know about the case, and if you feel so inclined, give us your thoughts on whether or not you feel Erica Kirk has a similarly strong case against Candace Owens and or even TPUSA as an organization.
So the statement of black widow, and I'm going to have to reel this in a little bit. I don't know how many times it was made, or if it's sort of become Candace's unofficial way of referring to Erica Kirk, but is this how she refers to her always, or was it said just once?
I can only remember one occasion where she said, hey, she warned someone, hey, be careful being around. Oh, she was talking about JD Vance. She said, JD, better watch out. That's a black widow. And something, she added something to that. But I can only think of one particular instance where it was that particular term was used.
My instinct tells me that alone is not going to rise to the level of what it needs to be a definitive. You know, the question is it definitively inferring she murdered? I don't think it is. I think it's derogatory, but it's not. It doesn't draw the inference of murder enough.
Fair enough. And do you have enough information to, like, let me ask you this. If Erica Kirk came to you based on what you knew, and she said, hey, I'm going to sue Candace for defamation, would you accept that case based on, hey, you think there's a really strong case that you think you would win?
Yeah. So my first question to Erica would be, what do you want to sue over? What specific statements? And the reason why is you're seeing a good example in Brian Hartle's complaint is you have to be chiseled. General statements and general themes that you've been talking bad about me, you've said things that are unfair, you've hurt my feelings, those don't qualify. So my first question, it's the same question I ask every one of my clients if you're going to be a plaintiff, is what specific statements are you going to give me that I can evaluate that you can say caused you reputational harm? Let's itemize those. And Erica Kirk probably has at least some basis to sue for defamation. And I don't have, specific statements other than if Candace has claimed, and I think there's an inference at least, that she murdered her husband, which I think probably listeners could find faster than me, then she probably has a very strong defamation case. I would argue that she probably has a better case than Brian Hartle. So yeah, and TPUSA similarly, the conspiracy allegation that they work together. I think I've even heard this, and don't quote me on it, but I think the allegation has been made that Erica and Turning Point USA were involved in taking out Charlie Kirk. And that's a pretty egregious thing to say. Now, again, footnote here, conspiracy theories are allowed. You just can't state them as fact.
Fair enough. Air Justice Gary, great guess. Raees, does Candace have to present during the entire trial? This high of a profile case could last 6 to 7 weeks. Would be nice if she was off the air that long.
You know what's interesting is she has to be present for the entire trial because she, obviously she's going to be a witness. Plaintiff will call her. She'll get cross-examined. She'll have her own direct testimony. She may get called back, depending on how long the trial. It's hard to say because I don't know how many witnesses there are. Ultimately, this is really, really early on. But yeah, she should stick around. It would be foolish of her to leave or be otherwise unavailable at any point during the trial. Something that just hit me like a ton of bricks to bring up is, if Candace operates in this case like what she did in the Macron case, she is going to become her defense lawyer's nightmare. Because you guys will remember, she doubled down on the Bridget Macron allegations. She started selling merch. She went episode on episode, and with full knowledge of the lawsuit. After whatever it was, September 2025, she continued selling merchandise, mocking the Macrons, collected donations based on her reporting them. So in the Macron case, I have this sort of bad feeling that she's going to do in this case, the Harpole case, what she did in the Macron case is continue to talk.
Yeah, no, she already has. She already has. I mean, again, I went through her entire podcast and that she essentially responded to this. I gave my own assessment. I'm glad to hear that. I think a lot of the things that I said are, in my opinion, non-legal opinion, counselor, that I think this makes it look worse. It looks more malicious. It looks like now she's trying to somewhat revise history and defend the things that she's saying, and at the same time doubling down on what she said. And that was just last Thursday. So she's already doing a long
road ahead.
Yeah. Going back to his other question, though, he said it'd probably take 6 to 7 weeks if it goes to trial. Do you think that's about accurate? What do you think the length of time for such a trial would be?
For the actual trial itself, it's hard to say because judges don't like to waste jurors' time, and it's a function of how many witnesses have to testify and how many documents. I mean, the Amber Heard Johnny Depp defamation trial, there were claims and counterclaims. They were suing each other. That lawsuit was long. I mean, I think trial was over a month, if I remember. It was a long trial. This could equally be. It could be a 2-week trial. It could be a 3-week trial. This question says, why is Erica and TBUSA taking so long? Okay, long to sue Candace after countless later. Yeah, well, listen. First of all, not everybody who gets defamed, assuming Erica was defamed, let's just assume that. Not everyone that gets defamed wants to be a plaintiff in a defamation lawsuit.
Yeah.
It's expensive. It turns your life upside down. You got to go through discovery. You got to testify. She's going to have to talk about her husband. I'm sure she doesn't want to. And so you make a judgment call and say, is the juice worth the squeeze?
Yeah, no, I don't think that. That's the other thing too. I think a lot of people on the side of Eric Kirk at TPUSA are like, well, just sue him. It's not a big deal. It is a big deal. There is a lot involved with that. And I don't think people truly appreciate how consuming that will ultimately be, in both for a time and resources, emotionally. I mean, I think that's often overlooked for sure. Let me ask you this. If because the other thing that's been kind of thrown out there was, and I've heard this and I've stated this, I thought this was probably a smart tactic, that if they are going to sue, let's say they're planning to sue, does it make sense for them to wait until after the murder trial of Tyler Robinson? Because that's going to be like 2 or 3 years, and then we get into the question of how long she'll be able to sue for defamation. Like,
yep, good question. So in most jurisdictions, the statute of limitations is going to control that question, and the statute of limitations for defamation claims is one of the shortest. It's a year, and it's a year from the date the statement was published. In some jurisdictions, it's as long as 3 years.
Yeah.
But in most jurisdictions, it's 1 year from the date of publication of that statement. The outcome of the criminal case, I don't think matters. If this guy pleads guilty to manslaughter or conspiracy, or for some reason the state can't prove, or the feds can't prove their case, and the jury doesn't reach a unanimous verdict on the criminal case, that doesn't mean that there could not be a civil lawsuit for whether it's defamation or some other civil lawsuit. So I don't think the criminal case outcome is determinative of a potential defamation lawsuit by Erica.
Yes, it's not a binary choice. Even if Tyler Robinson gets off, you still have to prove, or Candace Owens would have to prove, that she had evidence that Erica Kirk and or TPUSA was involved in some sort of conspiracy to kill Charlie Kirk. And, conversely, TPUSA and Erica would be able to say, hey, I'm suing you for defamation because we weren't involved. And by the way, you have to, we can prove that one way or the other. The assassination would cause damage to his reputation, loss of context. How will Harpole argue Snow caused the damage, not Charlie's assassination?
Yeah, so the question is one of causation. How will Harpole, the plaintiff, argue or prove that Snow caused damages? Well, and not Charlie's assassination? Certainly, this is something where an expert on PR would have to opine that the sentiment of the public changed at the time of Candace's statements. So certainly, this is a good question. Some people, just because Charlie was assassinated, might think, where the hell was the security? Why didn't they do their jobs? There should have been snipers. There should have been a vest. There should have been a glass this. There should have been that. What we're talking about is the delta between what happened to his reputation after Candace and where his reputation was after the assassination, that gap. Mm-hmm. And that gap can be filled by expert testimony. And we do this in cases where we evaluate how public sentiment changed after a certain statement was published. And that's how you would do it. He's right. He or she's right. You would have to prove that the reputation was directly harmed as a result of Candace, not something else like the assassination itself.
Fair enough. Raees, what major defamation case have you won during your tenure, and what was the experience like?
So, privilege prohibits me from talking about specific cases, but I do have a case that a client of mine has given me leeway in talking about. And recently, we had a pretty significant win in a defamation case where I represented a social media influencer, a fitness influencer, if you will, and he, according to the lawsuit, he got sued for defamation because he exposed, or rather spoke about, a fitness organization that was, the way he put it was, they knew that there were sex offenders working at these competitions, and they didn't do anything about it, or didn't do enough. So he got sued. He did like 13 Instagram videos. He got sued for defamation, and certainly calling someone a sex offender is a big deal. I feel like that word's thrown around a lot, like pedophile nowadays. But we were able to get almost all of the statements thrown out on summary judgment after depositions and discovery, because we showed that almost all of those people were in fact sex offenders or criminals or did something heinous. So his statements were either truthful or opinion. And it turned out to be a pretty big ruling. It's actually, you can find it in Google. I'm purposely being a little vague on it because even though he's given me permission to talk about it openly. So the case is now on pause because there's a U.S. Supreme Court case that impacts a question in our case, but there's an issue on appeal at the Ninth Circuit. So we still have trial left. That'll be a fun case. But look, something else. Sometimes a big win is just getting something taken down.
Yeah.
Right? If you come to me, Gary, and you're like, listen, Raees, I don't have millions of dollars, and I certainly don't have hundreds of thousands to blow in litigation. This really offensive thing is up. It's false. I need to get it down. And in a fraction of that budget, we get it removed. And if we're lucky, we get an apology. That's a tremendous win.
Yeah.
And we have those kinds of stories all the time.
Nice. Here's the last question, folks. I don't want to take any more super chats. But do you know whether news articles? Do you know whether news articles saying that Candace was arrested in the past at least once, could be twice, are true? Why have we not heard about this? That's probably a little outside your scope, but I'll let you take it.
Yeah, well, based on what I've heard and what my understanding of what's public record, I believe it has been verified that she was arrested at age 17 and charged with second-degree harassment and second-degree threatening regarding sending some digital messages to a peer. And, it was during a tumultuous time when she was in high school. It didn't lead to a conviction, but they were brought to light, I think, recently, in 2026. So a lot can happen by way of records disappearing in that span of time. You're talking about when she was a juvenile, talking about 2007. If I'm not mistaken, though, I think her husband was also arrested for DUI. And I don't know if she's acknowledged that, but I feel like
she's denied it. Actually, she's denied, saying that. And now they're saying that all these documents coming out, the arrest records and things like that, are also fabricated, because in the arrest record, one of many reasons, the arrest record, the Tennessee on the title at the top of the arrest report is misspelled. There's an S missing. I don't know if you want to give your opinion on that, but I can tell you right now, I've seen lots of different government documents that have misspellings and errors in them. I don't think that is necessarily relevant one way or the other, but I do think that, again, my opinion is that this is pretty clear, and that the record was expunged. I filed for the body cam footage, my producer and I. We got it back that had been. We didn't get that back that it had been expunged. We got it back that the record was not available, which is pretty wild, right? So, like, he was allegedly arrested for DUI with 0.0261, a 0.261 blood alcohol level, which is extremely high for people that don't know. And he was also on a green card status at the time. And, apparently, I don't think he was actually convicted of it. I think he ended up going to a treatment facility or something along those lines. I don't know. I don't know if you have any thoughts on any of that.
Well, my thought is, look, if something bad has happened that's particularly criminal and it's public record, I don't know why you would deny it. I think you lose credibility. And everybody makes mistakes. In fact, better is the person who acknowledges they made a mistake than trying to be perfect, because we're all human beings and we all make mistakes. But I think I'm not accusing her of lying. I'm just saying, if it's true and it's a lie, that's a hell of a lie. And a typo in a public record doesn't mean it's not the person who it is. Yeah, body cam footage would be hilarious,
Yeah. Apparently it's not available. We've tried. Other people have tried. Real quick, while we're on the topic, before I let you go, last question I'll ask you. I appreciate all the generosity.
Absolutely.
Been with how generous you've been with your time. A lot of people are pointing out that there's slight discrepancies in whether it's times, whether it's a little bit of this, a little bit of that, slight discrepancies between the different court documents. in the Tyler Robinson case. How common is that? Does that point out, does that highlight to you that there's any sort of conspiracy, that this is a cover-up? What's your thought on that? Because that seems to be what is trying to be pushed. That's the narrative being pushed. Like, oh, look at this. They got the time a little wrong over here. They said something that we know is slightly different over here. Give us your thought.
Let me make a general comment about what happens in criminal cases and why this even came up to begin with. The jury needs to find beyond a reasonable doubt at the time of the criminal case when it goes to trial, assuming there is no guilty plea or something else that happens in between. In order to reach a unanimous, and by the way, I'm pretty sure I'm right, but I'm assuming in this jurisdiction it is a unanimous guilty jury verdict, but let's just roll with that. The defense wants to poke holes in everything possible to show that there is reasonable doubt. And one of the ways that you do that is by showing discrepancies in public records. And if you can do that successfully, it could poke a hole in the evidentiary value of a document, but it could also lead to an instruction to the jury by the judge that you will disregard a typo, which is clearly just a typo. And that shouldn't affect the gravity of what actually is demonstrated in a public record. So I think one of the things, and tell me if I'm wrong on this, Gary, but some of the discrepancy was like the police custody issue, and there was a question about the Discord confession. Is that one of the ones that?
Exactly. So specifically, there are certain people trying to say that, oh, this is all a big lie, because he was actually in custody at 6:25 p.m. on the 11th, when all of the documents, all of the statements that have been given is that Tyler Robinson showed up around 9 p.m. on the 11th. Now, in one of the motion to exclude cameras, there's a statement in there where it is a transcript of attempted interrogation at 6:25 p.m. And this is where they're getting that from. And at the top, it says, at the evening of his arrest. Now, we have two different arrest reports. We have one that says basically 10 p.m. on September 11th. And then we have another one that says, matter of fact, I'll pull it up. It says 04 a.m. at on September 12th. And that seems to be considered by the defense and the prosecution as the official time. Let me share this tab instead. What they keep referencing as the official time. So we can see on the document right here, again, there, for clear, just transparency, there is another one that is Washington County that says he was arrested on 9/11 at 10 p.m. We have a second affidavit of probable cause for arrest. The defendant was arrested at 9/12:04 a.m. And then we have this statement up here that came from the motion to exclude cameras, where it says, on the evening of his arrest, Tyler Robinson declined to be interviewed without having an attorney present. The video encounter at Bates, a timestamp of, it also says 6:25, that part's covered up, 6:25 p.m. And so the allegation here is that, oh, he was actually in custody. And why this matters, because the real narrative behind all this is that the Discord chats were faked. And that because we know that those occurred at 7:57 Mountain Time. And the allegation here is that he was already in custody at 7:57 Mountain Time. And there's no way he could have had his phone. So I guess we take that further. This line of logic is that some deputy back there was creating Discord chats and confessions on his phone. So what's your assessment of all of that?
Certainly legal experts, and I think I fall into this category, is that the explanation we're getting is probably not satisfactory, meaning I think this is going to be a problem for prosecutors. Is it insurmountable? I don't know, but it certainly looks weird as hell. If you can't get your timeline correct in a criminal prosecution between the time of an arrest and a confession on an electronic server, that's a gigantic problem at a minimum from an optics standpoint, you know.
Yeah.
There's other evidentiary issues too here, right, Gary? I mean, there's the Bureau of Alcohol, Tobacco, and Firearms and Explosives. They couldn't conclusively connect the bullet fragment, if I'm correct, on the from the autopsy to the rifle found. And, you know, that's, as everybody knows, if the bullet doesn't match the gun, you may not get a conviction. So that's going to be really interesting. I think it was a Mauser 98. I don't remember what kind of rifle it was. It was a, at any rate, there's problems that things don't match up. Second thing was, you know, defense lawyers are saying, well, look, forensic reports tend to show that there's multiple people's DNA on some of the items. And so we need a deeper dive. That is absolutely relevant. That could absolutely impact a conviction here. Prosecutors say that the DNA was consistent with Robinson's, found on the trigger, but the fact that there's other DNA on the murder weapon is a huge defense. That's not something that can just be overlooked.
Sure.
Yeah, the weird one for me, is the sheriff who resigned. The sheriff who took Robinson into custody resigned. And I don't know. It's apparently there was complaints, you know, against the Washington County Sheriff's Office. The timing of it in relation to the custody timeline is not a coincidence that I think defense lawyers are just going to ignore.
Sure.
I'm not going to speculate on why he resigned or what happened.
I'm looking at,
but
because I have looked that up in the past. Nate Brooksby resign. The reason I believe that was given was separate from what was going on. Allegations came from an anonymous letter sent to Washington County Commission late February. I'll just share this so everybody sees it. And a lack of moral standards and ethics, sexual harassment of a deputy. That's what it was. Mm-hmm. So it was alleged that one of the deputy's spouses were sexually harassed by the sheriff himself. Also interfering with a criminal investigation into one of his deputies related to unlawful access use of criminal records. Commissioners discussed the complaints with him. Brooksby denied any wrongdoing and disagreed with the allegations. He then voluntarily offered his resignation condition on receiving $100,000 in severance payment, which the county agreed to as part of his separation agreement. So I don't know, obviously, the sexual harassment. I don't know if interfering with a criminal investigation into one of his deputies related to unlawful access to criminal records has any relevance to the Tyler Robinson case. I don't know.
I think it will be interesting to go back to the Discord confession, right? I mean, Robinson's defense attorneys definitely criticized, you know, the media for circulating. And again, is it irresponsible media? I guess the media wants to just cover the case of what's happening. Sure. But I'll tell you what will happen. I mean, prosecutors as well as defense have an incentive to get the actual metadata from the device and get the server. If there was a communication made on a server, particularly Discord, there's going to be a timestamp. Someone's going to be able to figure out.
Sorry.
No problem. Someone's going to be able to figure out when that message was sent exactly.
Yeah.
Confession message to their old friend group server. It's interesting to me that
take that for what it is. It's the only one. There was one being trafficked around that said 8:57 p.m. and that was just because it was a screenshot on the phone and we had the data on the phone. But the problem is we didn't know what there wasn't on that one for clarification was any sort of indicator of a time zone. And we don't know where that came from. So I guess it was assumed I did, but 8:57 meant it was Mountain Time. But here, the exact same confession, quote unquote, we do have a time zone indicator, and that's 9:57 p.m. Eastern daylight savings time, which would put it at 7:57 Mountain Time. So yeah, there's a lot of the problem that happens with all this is anytime that there is a gap in information, people are going to exploit that and fill it with conspiracy because look, it's fun, it's interesting, it gets a lot of clicks, views, and all the other things. So yeah, I don't know.
And you know, it's decisions. I mean, we saw this in the P. Diddy trial where sometimes evidence can cut both ways. Sometimes evidence is excluded from trial because of relevancy issues. But juries are sensitive to, this is a murder trial, right? I mean, juries are going to be sensitive to this stuff. There's still significant evidence that the prosecution has. Confessions to family members, text messages to roommates, notes under a note under his keyboard, surveillance footage, shoe impression, DNA. So, you know, beyond a reasonable doubt may not be an insurmountable thing, but I would do the exact thing that defense is doing. I would question all of this stuff. I would make them look like liars. I would, you know, what's nice about this is there's going to be a public hearing sometime between the 18th and the 21st on this issue, on the evidentiary issue, specifically the Discord messages.
They actually moved that to July. They got a continuance.
Oh, they did. They moved to July. Okay. So in July, we'll know. And for the first time, people will testify about it, and we'll see what happens. But somebody's got it, and it will come out one way or another. Indeed.
Well, listen, Raees, man, this has been awesome. This is hugely educational. I loved it. Very informative. Thank you again for being so generous with your time. Folks, I hope you guys got something out of this. Make sure that you guys go follow Raees. We got all of his social medias down in the description below. Make sure you go follow him, give him some support. I look forward to having him back on in the very near future. Anytime there's a legal issue come up, you know, we have Andrea from time to time. I love how objective Raees was throughout this, giving you kind of both sides of that story. That's what we're here to do. We're about the truth. It's not about cherry picking information. It's about delivering the information to you as truthfully and honestly and as in good faith as we possibly can. And then you deciding what you want to believe, and hopefully using some of the things that Raees and both of us talked about. Logic, evidence, man, it hardly ever steers you wrong. Thank you guys so much. Thank you for your love and support. Thank you for watching. And Raees, you don't go anywhere, but until next time, stay armed, stay ready. We'll talk to you soon.